essential to American interests and to all Americans. That said, in recent years, we've had a number of challenges to our patent system, some of which continue to threaten us and our ability to lead the world. So that's what we're going to be discussing today with our panel. Let me introduce quickly the 5 panelists we're going to hear from today. Let me start with Louis Foreman, founder and chief executive of Enventys, an integrated product design and engineering firm. He's also the founder of Edison Nation, a graduate University of Illinois Bachelor of Science degree in economics. The interest in starting businesses and developing innovative products began while a sophomore with his first company, founded in his fraternity room. And over the past 34 years, he's created 10 successful startups and been directly responsible for the creation of over 20 more. He's also frequently been an advisor on issues to the Patent Advisory Committee as well as Capitol Hill. Our next presenter will be Jonathon Romey, Assistant Director for Intellectual Property at MIT up in Boston. Jonathon is a patent attorney, has advised a variety of Fortune 500 companies on creating and implementing IP strategies, including Carneros Bay, Fidelity Investments, and IP Capital Group. Got his JD from Case Western and his BA from Johns Hopkins. Also with us today is Laurie Self, Senior Vice President in the Council of Government Affairs at Qualcomm Incorporated, where she specializes in U.S. international patent policy issues. She's based here in DC. Her focus is to ensure that IP laws and policies provide the necessary protections to support the company's R&D-driven business model and technology leadership. She was also formerly a partner with the law firm of Covington and Burling. We also are very pleased to have with us former federal judge Paul Michel, who served on the Federal Circuit Court of Appeals, the nation's highest patent court, for over 2 decades. And since retiring in 2010, has advocated publicly for restoring the U.S. patent system, which, until weakened over the past decade, was America's main engine of innovation and global technology leadership. He's testified, written, and spoken tirelessly to counter the false narratives about patents that continue to confuse policymakers. And finally, I'll introduce Brian Pomper here, who is serving as Executive Director of the Innovation Alliance, who are our hosts today, a coalition of research and development focused companies heavily engaged in patent policy debates. He served in that role since 2009, formerly as trade counsel to former Senate Finance Committee Chairman Max Baucus. So we have a very good lineup today. We have about 50 minutes left in our hour to talk about these issues. Rather than have presentations, I'm going to be asking each of our presenters a few questions, and then please feel free as we go along to put questions in the chat box, and we will try to get to as many of those as we can towards the end of the presentation. So we'll try to keep our questions and answers brief so we have more time for discussion afterwards. So let me start with Louis Foreman. And Louis, what is happening with the independent inventor community these days, and how has COVID-19 impacted innovation? How would you describe that?
Well, I think that's a great question, Michael, and I'm happy to announce that innovation is alive and well. The independent inventor and entrepreneur is thriving because innovation tends to advance and thrive and grow in areas and times of uncertainty. And we're certainly living in uncertain times right now. And so the independent inventor is coming up with new products, new services to not only make life easier, but to work ourselves through this pandemic. And so the ability for individuals and for small companies to pivot and to seek out those game-changing technologies is absolutely essential during these times.
What can inventors and entrepreneurs, what are they facing? Inventors and entrepreneurs raising capital during these unprecedented times. What are the challenges there?
Well, there's always a difficult time raising capital, but if you can demonstrate that your idea has economic value and that there is the ability to secure patent rights for your product to prevent others from making, using, or selling what you've created, then the odds are much greater that you're going to be able to attract that sort of startup capital that you need. It's one of the first questions that investors ask. They ask about the intellectual property of the company. Because that is, a really important aspect in the formulation of determining, the likelihood of success. Entrepreneurship is all about weighing risk and reward. And so the variables that go into that, of course, there's going to be risks, but if you can secure patent rights, that gives you that additional level of security that you need to, give you a little bit more runway and increase the odds of being successful.
We see that all the time. If you ever watch the TV show Shark Tank, one of the first questions they always ask these inventors is, do you have a patent for this device? Because that's what they want to know in order to get their money back for this investment. Finally, how do you think Congress can help support the efforts of the independent inventor? Louis?
Well, I think it's hard enough being an independent inventor to begin with. What Congress can do is provide the certainty, the surety that the independent inventor is looking for, knowing that if they follow the rules, right? If they come up with an invention that's novel, that's non-obvious, if they file their patent and then they're granted a patent, that they're given the same property rights that inventors for decades have been receiving in the past. And so all we're looking for is to make sure that the rules are fairly placed for the independent inventor and allows us the opportunity to recoup the significant investment that we're making to launch a product, to hire employees, to start companies, and ultimately try to capture the reward for the risk that we're assuming.
Let's turn to Jonathon Romey now from MIT. And Jonathon, as a university, and I work at one as well, I know the importance of the Bayh-Dole law that was passed over 40 years ago this year. That really has accelerated the work that universities can do in this space. Tell us a little bit about the Bayh-Dole Act and how it applies to universities like MIT.
Absolutely, and thank you, Mike, for having me. I appreciate it. You referenced it a little bit earlier. You mentioned all the innovation that came out, and from the Autumn paper, the fact that it added $1 trillion to the economy and hundreds of vaccines and approved drugs. That all started with the Bayh-Dole Act, and the Bayh-Dole Act went into effect in December 1980. Essentially what it did is it established a federal policy where an ownership and title to any invention that was made in whole or in part with federal funds was granted to universities or the small businesses that were the recipients of those funds. Now, in exchange for that, the federal government would reserve for itself a royalty-free license to practice any invention for government purposes. Now, that really kicked off the tech transfer industry as we know it. And as you mentioned before, it's been an unqualified success. Prior to Bayh-Dole, it was estimated there were around 30,000 technologies that were just sitting in the labs that were waiting to go to the marketplace that never got there. At MIT, we received probably around $700 million in research funding annually, and roughly 80% of that comes from the federal government. And MIT Lincoln Labs receives around $1 billion in funding. Because of Bayh-Dole, MIT and universities like us, we have the right to take title to that technology and the results from the investment. Knowing that we have the title to that provides us with a certainty that we can then take that early stage innovation and try to move it out into the marketplace where it can be of benefit to everyone. And then furthermore, if that invention becomes marketable, if it does get into commerce and produces revenue, part of that revenue goes back into the inventors. Part of that revenue goes back to their department. Part of that revenue goes back to the school, which then in turn funds additional research and further incentivizes more inventions, more research, and more innovation.
So you've talked a little bit about how the patent system is important. And I guess, what is your biggest patent concern? And how has that impacted the technology licensing that MIT does?
So really, our biggest concern is the uncertainty. It's the uncertainty, as was referenced earlier in the video. It's uncertainty around patent eligibility. It's uncertainty around the enforcement, the ability to enforce your patent. And really, it's about, a lot of that's sprung out of the patent eligible subject matter interpretations under 35 U.S.C. 101 and the Alice Mayo line of cases. And so because of that, we have a question around some of the patents that we have, whether or not they're valid. We've got some questions around what types of subject matter to pursue, and the decisions from the court make this a moving target for us. And it really impacts what kinds of things we pursue patent protection around. We tend to try to file our patents on stuff, or I should say, our patents are filed on really nascent technologies. They're the results of innovations that come out of our labs, and those really seed the ecosystem and encourage investment. And without certainty, that investment doesn't happen. And furthermore, I'm really also concerned about the certainty as it impacts emerging technologies, especially things like quantum computing and AI. And I think the USPTO and Director Iancu have really started to take the office in the right direction with updated guidance around subject matter eligibility with respect to 101 and a call for feedback around AI. But I don't know if we're actually really doing enough vis-a-vis other countries like China, where they do have a little bit more certainty going. And so that's something that I would ask Congress to look at, is trying to put certainty back into the system.
Right. Well, you mentioned Section 101 and some of the court decisions, and we're going to get to Judge Michel in a minute here about that. But let me turn now to Laurie Self from Qualcomm. And Laurie, we hear all the time about the new technology 5G, which I know you guys are spending a lot of time on, which is going to revolutionize how we use data to control all sorts of things in our communities and in our homes. Talk a little bit about 5G and its potential, and then how important it'll be to have strong patents to really get the full bang for our buck on 5G.
Sure. So you have to think about the different generations of cellular technology. So 2G, 3G, 4G, now 5G, as both evolutionary as well as revolutionary technology. So these are transformational shifts, if you will, in terms of the capabilities of cellular communications to transmit data, ever growing amounts of data, more efficiently, more securely. With 5G, you will see cellular becoming the connectivity foundation, if you will, for all communications across all verticals across society. And we've seen the importance of that connectivity, I think, in a very pronounced way during this COVID crisis, where your ability to work, your ability to sustain a small business, to sustain distance learning, telehealth, all of that depends on ubiquitous connectivity. And cellular communications really is that robust, resilient foundation for communications. As we move into the 5G era, and we're just now at the very beginning of the 5G era, usually these generations of cellular communications are about 10 years of continuous R&D, and that's where patents become such a critical part of that investment equation. But as we move into 2021, 22, 23, that's when you'll see this kind of revolution around connected cars and industrial IoT and factories of the future, and where you'll start to see really, groundbreaking advances in telehealth and distance working and learning and so forth. So one of the really exciting things about each generation of cellular communications is that there are yet to be imagined industries, business models that will be built on top of cellular communications in the same way that we saw, with the Ubers and Airbnbs and so forth during the 4G era. So what we do as a company is we anticipate 5-10 years in advance what kinds of improvements need to be made to the cellular connectivity fabric, as I said, in order to enable a new generation of cellular communication. So our role as a company is to be that R&D engine of the mobile economy, and to really look into the future with the world's most sophisticated wireless engineers and scientists to sort of think, here's where we need to kind of push the boundaries even further for cellular communications to become yet another game changer in our economy. And of course, with 5G, you're also seeing a recognition that these technology sectors are not only critical to economic growth, but also to national security. Patents, that is, Lewis and others were talking about the role that patents play in terms of venture capital, private capital. For a large company like Qualcomm, for us, it's that same investment calculus, that same investment risk that we're taking, but because we're a large company, we're self-funding those R&D investments. And so as a publicly traded company, we have to be confident, our board has to be confident, our shareholders have to be confident that ultimately those long horizon, big risk bets in R&D will ultimately be protected in the marketplace through patents, can be commercialized in the marketplace through licensing, and that there will be a return on investment. And I think it's worth emphasizing that for commercial companies like Qualcomm, based in a market-based economy where we are self-funding the R&D, some of those same pressures don't exist in countries like China, where there's more government subsidization of R&D. And I'm not suggesting we want government subsidization of R&D, but we do have to be very mindful that patents play that critical role in enabling that long horizon investments in R&D in this country.
Well, and you mentioned too that how important is it that America be the leader in this technology? Because I know there's a lot of competition with other countries to try to be the first one to create this whole new way of doing business.
Well, I think in terms of those imperatives of economic, national security, economic growth, I mean, again, particularly at this moment in time where we're looking at a very difficult economic recovery, having that R&D leadership position in the United States, I think, is critically important. For the company and the country that has that insight into how the R&D is designed, is always going to have an advantage vis-a-vis competitors or others in the global marketplace. There's also a significant first mover advantage that comes from having that R&D position at home. And one of the roles that Qualcomm plays, and I'm sure other R&D intensive companies play the same role, is we partner with others in the mobile ecosystem, the carriers, the auto companies, the manufacturers who are trying to really fully benefit from these new technologies and ensure that these new technologies have the capabilities that they need. So there's this mutually beneficial partnership that we can play because we are the leaders in the R&D. So I think there's tremendous importance and benefits from having that leadership position in the United States. And again, patents are a critical part of that ability to sustain that R&D leadership position.
Judge Michel, there was some allusion earlier to the problem that the courts have caused for some of this patent eligibility discussion and some other things. And obviously you dealt with these issues for many years when you were on the bench. And I guess, can you help us, for a lay audience, to explain what Section 101 is all about and how you think things have kind of gotten a little off kilter with some of the rulings that the courts have made the last few years? Do we have Judge Michel there? Maybe he has gotten disconnected here. So let me, while we wait for hopefully Judge Michel to get back on with us, Brian.
I'm with you now. I'm sorry, I got automatically muted somehow.
Oh, okay. I asked you just.
So in Section 101, the Congress set out categories it wished to make eligible for patenting. There were 4 categories: machines, processes, compositions of matters, and manufacturers. And that statute was followed to almost complete extent until 2012. There were a few cases before 2012 where the Supreme Court and sometimes lower courts found outlier patents that were directed to a mathematical formula to not qualify for eligible inventions, even if they seem to fall in one of the 4 categories. So no harm, no problem until 2012. And in 2012, in a case we refer to by shorthand as Mayo, the Supreme Court basically displaced the law as passed by Congress with its own views of what should be eligible and what should not be eligible. It expanded the reach of its ineligibility law vastly compared to all the prior cases. Before, an abstract idea was only ineligible if it was limited to a mathematical formula. But in the Bielski and Alice cases, the Supreme Court upended that law. And in health technologies, in Mayo and in another case called Myriad, The court likewise completely changed the prior understandings in industry, among patent lawyers, in the patent office, and in the courts with a whole new regime. So the new regime goes by the shorthand Alice and Mayo for those two lead cases. And essentially, they changed the law from being if a court-created zone of ineligibility was all that a patent covered, that's the pre-Mayo law, then it would be deemed ineligible. But what Mayo said, in effect, is if the patent includes one of these court-made ineligible areas, then the patent is ineligible unless it can be shown to be a new invention which really relates to other provisions in the Patent Act as passed by Congress. So essentially, and I'm very sorry to say this as a former judge, a retired judge, but basically the Supreme Court has usurped the role of Congress in setting national innovation policy by deciding what types of inventions would be eligible for patenting and what types would not be eligible. And it seems to me bizarre in the extreme that in a democratic country, 9 unelected judges who are not familiar with investment dynamics in the private sector or technology are making national innovation policy on this critical threshold test of eligibility and displacing the decisions made by Congress. So the solution seems to me to be very clear. Congress should take back control of the issue of eligibility by abrogating the Supreme Court Alice Mayo regime, which would restore the law to what it was before 2012 when everything went pretty well. So that's it in a nutshell. Some very good proposals were being framed by the Senate IP subcommittee, and then that effort got derailed late last year. It should be resumed and a bill should be passed that would wash away the extremely harmful Alice Mayo regime, which is terrible economics for innovation and actually terrible law as well.
Well, at the time of the coronavirus, Judge, I know one of the areas that it's impacted most is sort of the diagnostic tests. It's now very difficult now to get a diagnostic test in many cases approved for a patent. Can you talk about the negative impact that's having on healthcare and other kinds of things?
Well, I don't think it's a coincidence that the United States became short of diagnostic tests relevant to viruses like COVID-19 virus because with the Alice Mayo regime for the last 8 years, the incentive to invest in developing new diagnostic methods and related tests fell through the floor. So many industries have been very hard hit by the Alice Mayo regime, including all the vast number of industries and technologies under the broad heading of computer implemented. But in the human health area, it's been absolutely devastating. It was mentioned earlier that uncertainty, unpredictability of eligibility is a killer of investment and is rampant in this field now. The one area where eligibility law is not unpredictable is actually the area of diagnostic methods. Every single diagnostic method that has been reviewed by the Federal Circuit was found ineligible by judges who complained that they were forced to do it even though they thought it was wrong and unjust and bad policy by the Alice Mayo regime dictated by the Supreme Court, which of course they're obligated to follow. So diagnostic methods and related human health technologies are being impeded in their development by this practical results of this Alice Mayo regime, which was ill-designed from the start. But now that we've had 8 years of experience with it, we know exactly how devastating it is, and it hit hardest in the human health area. And so the unpreparedness of the country for COVID-19 didn't come as a surprise to me.
One of the things the Constitution talks about, and the Constitution mentions both patents and copyrights, which is an amazing thing the Founding Fathers that foresighted to include in our original document to set up our country, is this exclusive right, the right to exclude others, the right to say, if you want to use my invention or print my book or whatever, you have to get my permission or my license. Well, how has this now been kind of flipped around where we have people infringing and having little or no penalty to pay for that?
Well, it's somewhat similar to the eligibility problem. The Congress in the Patent Act provided for injunctions to be issued by the trial courts once infringement was proven and the patent was shown to be valid, or what lawyers call not invalid. And then along comes the Supreme Court in 2006 in a case called by shorthand eBay, and they said, well, we don't agree with that. We think there should be two classes of patent owners. Those who manufacture, they should have full rights and be able to get injunctions once they've proven at trial that there was an infringement. But companies that are not manufacturing products are second-class citizens and should not be able to get injunctions. And of course, that category includes individual inventors, small startups, small business, emerging technologies, universities, university spin-offs, hospitals, research institutes, engineering firms like Lewis Foreman's and many others. So they've created a bifurcated system where the rights are totally unequal depending on whether the patent owner is manufacturing the patented product or not. And since the Constitution made it clear that it was not a right to make something, but a right to prevent others from making something without your permission when you invented the technology, if you can't get an injunction, the right is almost meaningless. So now there are vast numbers of companies that, as a practical matter, probably can't get an injunction and normally don't get an injunction just because they're not making the product. So again, the Supreme Court decided they didn't like the way the law was operating as enacted by Congress for all those many, many, many decades. So they instituted a change on their own, and the response should be exactly the same. Congress should step in, effectively saying, no, we're not going to let the courts decide to make second-class citizens of non-manufacturing patent owners. It should be the same for all patent owners. So we're going to pass a statute to make it clear that non-practicing owners are as entitled to injunctions as anyone else. And the Stronger Patents Act does exactly that. And I hope that along with passing a bill to abrogate the Alice Mayo regime that has made a mess of eligibility, that the Congress will also pass the Stronger Patent Act in order to restore injunctions for all patent owners.
One more issue, Judge. It's been mentioned earlier, the Patent Trial and Appeal Board, which grew out of the America Invents Act back in 2011 when Congress did a major renovation of patent law. This was supposed to be a kind of a alternative to going to court where you could actually appeal a patent at the patent office. And I guess you feel like many others that system has not really worked very well. In fact, it has made things worse. Can you speak to that a little bit, what Congress might do to address that issue?
Yes, the three grave problems in the functioning of our patent system are covered by your questions. First, eligibility. Second, availability of injunctions. And third, the operation of the Patent Trial and Appeal Board with regard to three types of reviews created by the Congress in the America Invents Act way back in 2011. And it's clear to me, as you say, that the Congress contemplated the inter partes review, one of the three types of review, to be an alternative, a faster, cheaper alternative to complicated, expensive, slow district court litigation. But it turned out not to be an alternative. Almost every case in front of the Patent Board already is being litigated in the district court. So it's not an alternative. It's now become the gateway, because in almost every case, the district court will stay further progress of the litigation in court to await the result coming out of the PTab, which takes about a year and a half. and then there are inevitably appeals that take another year and a half. So suddenly, we now have, for a patent owner, assume a valid patent that's actually being infringed, a 3-year timeout while the PTab and appeals therefrom proceed before the district court will move forward on the patent case. Now, there are exceptions, but that's the general pattern, and it's been very, very harmful. And also, Congress tried to engineer a system where repeat attacks on the same patent using the same evidence couldn't happen in the patent office or in the courts. But the way it's actually worked out, it can happen. It happens routinely. And so obviously the protection against repeats has proven in practice to be totally ineffective. And so once again, the solution is simple. The Congress should go back and re-engineer the details of the AIA reviews to bring them in line with the intent of Congress that was pretty clearly stated back in 2011, because compared to the actual practice as it's worked out in the intervening years, it's not at all what Congress wanted. So once again, Congress has to come to the rescue, which they are entirely entitled to do without a doubt, because they created the Patent Trial and Appeal Board and these AIA reviews in the first place with certain expectations which have been dashed by reality. So the solution is Congress should swoop back in and fix it.
Brian Pomper, adding cleanup here. This last year we saw a lot of activity in the Senate as they began to think about making changes to this Section 101 that's been discussed here today about eligibility. And, can you talk about some of the concerns that you and members of the Innovation Alliance hope to address with that effort? And where do things stand in that process as we're midway through the second year of this Congress?
Let me associate myself with Judge Michel's remarks on Section 101. He alluded to judges who are forced to try to interpret this incoherent mass of the law, being frustrated with the current state of the law, effectively really asking for clarity, either from the Supreme Court or from Congress. And I just thought to really make the point, I want to read just a couple sentences from one of my favorites. It's from a case called Interval Licensing versus AOL from 2018. It's Judge Plager's dissent, which I think really encapsulates a lot of how judges think about Section 101 these days. He says, "Today we are called upon to decide the fate of some inventors' efforts, whether for good or ill, on the basis of a criteria that provide no insight into whether the invention is good or ill. Given the current state of the law regarding what inventions are patent eligible, and in light of our governing precedents, I concur in the carefully reasoned opinion by my colleagues in the majority, even though the state of the law is such as to give little confidence that the outcome is necessarily correct. The law, as I shall explain, renders it near impossible to know with any certainty whether the invention is or is not patent eligible. Accordingly, I also respectfully dissent from our court's continued application of this incoherent body of doctrine." So I like that particular formulation, because I do think it articulates, and you can really sense, I think, the frustration from the judge here. And judges are doing their best to try to apply the law in a coherent, consistent manner, but it is just coming from the Supreme Court. The Mayo-Alice line of decisions is not coherent, is not consistent with prior precedent. It's a mess. And so companies in the Innovation Alliance, we take to heart and have long believed what USPTO Director Andrea Iancu says, which is what you really want in a patent system is stability and predictability. I represent clients in lots of different areas of business, and not just in patent issues. And I often hear from these clients who say, listen, I don't even necessarily care what the rules are. I just need to, or whether the rules are good or bad. I just need to know what the rules are, and then I can work around them. The worst thing is having unpredictable rules. So the fact that we are in this environment that relies on drawing incentives to draw money into the system on the basis of the strength of your intellectual property, and we've injected this terrible uncertainty on the basis of 101 into the system is a disaster. It's a disaster for us. And I think it's sort of one of these slow burning fires where, you know, I think those of us who are in the patent community have known this for quite some time. And I think gradually over time, people are looking at various indicia of the performance of the US patent system and kind of scratching their head and wondering, well, gosh, why did China register more patents for the first time in history at the World Intellectual Property Organization last year? You know, why did that happen? And why are US companies increasingly foregoing trying to enforce their patents in the United States and instead going to Germany and believe it or not, even China sometimes, because in those cases, the law is clearer and protects patents more robustly. So I think from our standpoint, the Innovation Line standpoint, we don't look at it like we are trying to get some special benefit from Congress or from the courts or something that's a leg up for our companies over everybody else. I think we view it as we're trying to get back to even where the system was when it was working and didn't disadvantage inventors and small businesses and others who are going up against these very well capitalized companies. So that's, I'd say, just we're really concerned about the state of the law presently on 101.
Well, I know the Senate Judiciary Committee spent a good part of last year looking at this issue, had a lot of hearings, did some drafts and so forth.
Yeah.
But nothing came out of that. Where does that process stand, do you think, going forward?
I think there are still a lot of discussions that are taking place off Capitol Hill, not so much, I think, on Capitol Hill. I think the previous effort, and Laura, I'm very thankful to Chairman Tillis and Ranking Member Coons and their staffs for undertaking that effort. It's a pretty gnarly area of the law, very complicated, but they did try to undertake it. It's very complicated. And so it's not a surprise that it would have foundered perhaps on the first attempt. And there are a lot of people sitting around the table. And I think there eventually Congress is going to have to address this, or like I said, we're just going to continue to see the air come out of the balloon here in the United States.
The other bill we wanted to talk about was the one referenced in the video earlier, which was the Stronger Patents Act, which has been out there for both the House and Senate. It's back again in this Congress. Can you talk about that legislation and what it would do to address some of these concerns that have been raised here?
Yeah, sure. Thank you. And again, it's this is not something where we are seeking to go back to ante, right? We're the Stronger Patents Act, and there are many people who weren't crazy about the creation of the PTab and the post-grant review and inter-parties review system back in 2011. The Stronger Patents Act doesn't say we're not going to get rid of the system. It just tries to provide some balance into the system, because I think many people believe the way the PTab was structured and subsequently how it was set up by the judges of the PTab really put a thumb against the scale for patent enforcement. So you originally had the PTab judges setting up a different claim construction standard for how they would interpret patents at the PTab versus how the claim construction standard judges use in the courts. And recall, I can't remember who said it, but the PTab and the inter-party system was intended to be clearly, if you look at the legislative history, an alternative to court litigation. It was intended to be a cheaper, quicker alternative to court litigation, not an easier forum in which to invalidate patents. And that's what it became through this much lower standard that the judges or the PTab judges would use in order to figure out whether a patent is patent eligible, basically, or should be knocked out. Because of the way that the system was structured, there's no, unlike in district court, there's a presumption of validity on patents. And you would expect that, right? You've gone through this often multi-year process, working with the examiner, going back and forth, getting a patent. You've adjusted the terms of your patent in order to comport with the prior art and how the examiner tells you it needs to be drafted. You get your patent, fantastic. There, you can go out and you can try to attract investment. Now we've got this PTab system where you get dragged into it, and guess what? There's no presumption of validity again. And the petitioner who brings a PTab action can prove your patent is invalid just by a preponderance of the evidence. So it's a system that is skewed against patentability, perversely, since it is from the patent office. So what does the Stronger Patent Act try to do? It tries to restore some balance. And to his credit, I should say, Director Iancu has taken a series of measures to try to restore some of that balance through administrative means. He has, for instance, changed the standard of claim construction that's used at the PTab to try to harmonize with what's in the court so that you no longer have this forum shopping element. They have established a pilot program to try to make it a little bit easier to amend your patent so that you can comply with prior art or any concern at the part of the PTab judge that it may be invalid. They have updated their trial practice guide to make it clear that it should be the rare circumstance where a second subsequent action is brought against a claim in a patent. I should say that's been a problem, is these serial patents. Innovation Alliance has a subsidiary of its member, TiVo, Romi, had a circumstance where they were negotiating a license with a customer. And unlike the entirety of the rest of the ecosystem in which Romi sells its product, this one customer refused to renegotiate the license, refused to sign up for it. And so Romi brought an action against them for patent infringement for continuing to use their technology without paying the license fee. And this company then brought 45 PTab actions, 45 petitions against 15 Romi patents to just try to grind them down in the process, to spend all of this money to delay any kind of enforcement. It's a good example of this efficient infringement circumstance that the video tried to show, where deep-pocketed infringers will use the system to try to beat patent owners into submission to either just dropping any infringement action or accepting a artificially low licensing fee. So Director Iancu has taken these measures. Part of what the Stronger Patent Act seeks to do is to enshrine them in law, so that, again, to preserve the stability and the predictability into the system, so that you don't have the next director, whenever he or she is appointed, comes in and changes everything back, or can loosen these standards. We want to try to enshrine it in the law. So it enshrines the claim construction standard that's harmonized with the courts. It makes clear that there's a presumption of validity in the post-grant proceedings. It requires that petitioners have to prove patents invalid by clear and convincing evidence. It creates a standing requirement so that you can't have gamesmanship with, as has happened in the past, people who bet in the stock market, shorting a company's stock and then filing a PTab action, which may or may not be even well argued, but just because that would make the stock price of the company dive. So there's a standing requirement. You got to have been sued or accused of infringement. There's a variety of other measures, but and of course, most importantly, I'd say in the Stronger Patents Act, it does restore a presumption. It's a rebuttable presumption, but a presumption that if you have a patent and if it's found to be infringed, you can get an injunction. Very important. I talked to many patent owners across the spectrum, and they all say this is the most important element for them, is the ability actually to enforce their patent, because otherwise there's no incentive for these very large companies to sit across the table from a patent owner and try to negotiate any kind of settlement, any kind of structured idea for how they can pay for the license that they're now using. So you do have the circumstance where very large companies will tell the smaller companies, oh, you want a license? Go pound sand. Sue me. And once you sue me, I'm going to file PTab actions arguing that your patents are invalid. And I'm going to stretch this out for years and years and years. And by the time you finally are able to get any kind of reward from me, really, it's just going to be the same kind of licensing fee I should have paid at the beginning, maybe at best. But you'll have spent years and untold millions of dollars trying to enforce your patent. So you should just give me a license now for very little, or I'll see you in court. That's a really bad way, I think, to have a system. It does not provide the kind of stability and predictability I think that we would want in a system that relies on voluntary investments in promising innovation.
We have about 10 minutes left. I want to encourage anybody in the audience, if you have a question, please put it in the chat box, and we'll try to get to some of those if we can between now and the end of our session here at noon Eastern. I have a quick question. I want to follow up with Jonathon. We're hearing a lot about the coronavirus. I know lots of universities are doing research to try to find out how to cure the virus, what are vaccines that we could have, what are treatments that we could have. But can you talk a little bit about the fact that the treatments that we're using now, the medicines we have now, the techniques we're using now, are based on the bi-dole ability for previous research to kind of help us while we're looking for the next great thing. Can you talk a little bit about that, Jonathon?
Sure, absolutely. And so, as you mentioned before, bi-dole had an incentive to get that technology out into the world. And because of that, also the other thing that really hasn't been mentioned, but patents allow others to work off of previous research that has happened before and let people go and stand on the shoulders of giants, if you will. And so what we've done, how we've used both the previous patented research and the coronavirus, it's allowed us, bi-dole has allowed us to take some of that federal funding. We've worked on at least 124 projects related to COVID, and we've had 177 faculty that have been involved in this process. And so by doing so, it allows us to then try to use both some of the research that's come before, use those federal dollars to try to get that out into the marketplace and try to accelerate either a vaccine or a therapeutic that may otherwise have been a little bit slower in coming along. And so those strong patents, while we may or may not enforce them, we at least have the rights to them. We're giving out, we have sort of a NERF that we're working on for that, for people to come in if we do find something and they want to take a non-exclusive royalty free from us, we do have that in place. And so that's accelerating some of the adoption of these technologies and bringing them out to the marketplace a little bit easier than they would have been had we not had bi-dole in place.
Right. Judge Michel, you talked about the judges getting a lot of this wrong the last 5 or 10 years. Is it because, are they antagonistic to the patent system? Do they just not understand how the patent system works? What is the reason, do you think, behind that?
Well, I think that there's a struggle going on in the country about who should be in control of innovation policy, of patent policy, whether it's with regard to eligibility or injunctions or the operation of the PTab. And the attitude, in my view, of the Supreme Court is that they think they should be in charge at the expense of what Congress has actually written into the statutes. And I think that as far as I can speculate, that like many on Capitol Hill, the Supreme Court justices, having been inundated for more than a decade with scary stories about trolls and vastly exaggerated claims by a small number of very large, very rich, very aggressive companies who apparently infringe quite a lot. So they took on board this idea that the patent system was a mess, was not getting good results, was not a proper policy. So they felt like, well, we better step in and fix this. And they were not well prepared to do it competently and effectively because they don't have the tools in the case in front of them. They just have the record put together by the two parties, very narrow, very limited. They have very limited time to study the issues more broadly. By comparison, the Congress, as they did with the AIA, for example, often takes years and has dozens of hearings and hundreds of witnesses and thousands of written submissions by all kinds of experts and economists and patent lawyers and industrial leaders and others. So the Congress has the tools and the traditions and precedents to do the kind of in-depth economic analysis that's required, and the Supreme Court doesn't. So they were the wrong people to be dictating these policy issues for many reasons, not only because it's undemocratic since they're unelected, and it's not appropriate for national policy on broad terms to be made by judges, but beyond that, they don't have the background, the expertise, the experience, or even the mechanisms to develop the facts in order to be able to do so competently. So in the in the vernacular or the colloquial saying, they got way out of their lane because they overreacted to publicity about trolls.
We just have a few minutes left, so I thought I'd like to give everybody a chance to answer a more general question, which is, if you had to pick one thing, or what would you think that we need to do most to ensure that the U.S. patent system continues to serve our interests and keep our country strong? So let me start back at the beginning here with Louis. And Louis, what would be the one guiding thing that you hope policymakers would focus on the most moving forward? Or what could they do that would be most helpful from your perspective in this patent innovation ecosystem?
You know, I think the consistent thing that's gone throughout all the panelists is the lack of certainty. And so being an inventor, being an entrepreneur involves a tremendous amount of risk. And when that inventor pursues their invention, it involves investing significant time and resources. It may involve taking a second mortgage on the house, or quitting a job, or cashing in the 401k. And the inventor assumes those risks because they believe that there's some sort of upside or reward. And you've got to balance all of these external risks. But the one thing that they shouldn't have to worry about is whether or not the US Patent Office stands behind an issued patent and allows that patent to be valid.
Jonathon, from the university's perspective, from MIT's perspective, what would be the one message you would give to policymakers, Congress, and judges about this, the importance of patents?
I'll echo Louis's point about certainty, but I'd also say it's around education as well. I'd like them to make sure that they're educated on the policies that they're making and the impacts to us. So because of the uncertainty, you know, we are a driver. We are one of the early stages, and we need that certainty in order to be able to move to get investment for technologies that may be market making. And so because of that, we need the education to go to the Congress. We need education to go to the judges and the Supreme Court to be able to understand the impacts of their decision as it applies to our inventors and our investors.
Laurie Self is representing a major corporate perspective. What is your thought about this if you were going to speak to policymakers?
Yeah, well, I would certainly agree with the previous comments, but I think restoring the right to an injunction is critical. If you think about what our innovation economy is built upon, it's a system of property rights backed by a rule of law. And when the patent property right is no longer backed by a right to an injunction, you have really destabilized the role of the patent in encouraging, incentivizing lawful use of your patented technology and mutual voluntary collaboration in the use of your technology. So, you know, our R&D engine is funded in large part by our licensing program, and that enables this incredible ecosystem where the entire world can use our patented technology. But if we can't enforce our rights because there's no right to an injunction, it really discourages and incentivizes you know, the opposite behavior. In other words, the efficient infringement dynamic that was described in the video, where large companies will knowingly violate patent rights, recognizing that at the end of the day, the greatest risk for them is the possibility of patent litigation, you know, years down the road, maybe a damages award, years down the road, at which point the patent owner may no longer exist because they've been driven out of business. And of course, you have to also factor in how does that you know, uncertainty, unreliability of patent rights, how does that discourage upfront investment in innovation? You know, we've been talking throughout this panel about patents becoming that sort of market signal for venture capitalists, that incentive for private investment by corporations. So I think it's important for folks on the phone to understand that the purpose of the injunction is not to, you know, stop products from reaching the market. It's to encourage voluntary, lawful use of the patent rights. It's really a means of discouraging litigation and really creating an ecosystem that rewards and incentivizes R&D investments. So that would be my that would be my number one recommendation.
Judge Michel, very quickly, anything to add?
Just the global perspective, because strong patents are routine in every European country, in every major Asian country, including China. Injunctions are routine in those jurisdictions. Eligibility is much broader than it is now in the U.S. So in a global competitive marketplace, the U.S. has put itself on a suicide mission by the installment plan for no good reason, and we should fix it right away.
You get the last word, Brian, very briefly.
Outstanding. I agree. I think, look, a patent gives the right to exclude. If you have that right to exclude, but you can't get an injunction, you don't have a right to exclude. So from my perspective, you need to restore the ability to get injunctions.
I want to thank all of the panelists for being with us today. Also hope you thought the video was useful, and I hope the participants found it useful. If you have follow-up questions or want to reach out to the group, probably best thing is to go to the Innovation Alliance that set this up and let them know you have follow-up questions or information. All the panelists will be happy to respond to you afterwards. I want to thank them all for their time, and I want to wish everybody a great Monday. Thank you all for being part of this presentation today.
Thank you, Mike. Stay safe and well, everybody.